Greetings everyone, Jonathan here from Plagiarism Today, and today I want to talk about an interesting and I think many will find somewhat disturbing ruling coming out of Israel today, and that ruling involves RSS feeds and basically the ability of others to copy them and republish them on their sites without your explicit permission. Now the issue started with a news site in Israel that apparently was taking some other guy's RSS feed and republishing it on their site. The guy objected to this. They removed the feed, but it still wasn't enough for this gentleman. He filed a lawsuit, and the Israel court ruled, and this is where it kind of goes against both legal thought and what little legal precedent we have in the U.S. and elsewhere, ruled that the republishing of RSS feeds was legal. I've talked about this at great length, why I don't think it should be legal and why I don't think it is legal, at least in the U.S., but in this Israeli court, they ruled that it was legal, at least in this case, though there is some indication that the courts are also somewhat divided on this in Israel. So this may not be the end of it there either. But the point of the matter is, this case hinged on what we in the United States would refer to as the implied license idea. Basically the idea that by publishing an RSS feed, especially a full one, you're giving others an implied license to republish it on their sites. I've never bought that for several reasons, but one of them being that usually with an implied license you have to take some kind of explicit action, like I am publishing a website. Most blogging platforms, be it WordPress, be it Blogger, be it Tumblr or whatever, they create the RSS feed without any action, and many people who use those services don't even know they're publishing an RSS feed. In fact, knowledge and understanding of RSS is probably going down, considering fewer and fewer people are using it directly. So just something to think about there. And there are other problems I have with it. I did a whole article about, I've actually done 2 articles why RSS scraping is not okay, but I'll hold off on the long rant there. However, if you are a copyright holder, though, and you are worried about this, there are 2 factors in this case that might give you a little bit of hope. First, this news agency's arguments hinged on 2 simple facts. One, they did attribute all uses of the content. They were all properly attributed, and apparently there's not much discussion or debate there. They were. We talk all the time in copyright law about how attribution really doesn't affect the law, and that plagiarism and copyright, though related, are 2 separate beasts, but this might be a time where it actually matters a great deal, so something to consider. And the other factor was that they removed the content immediately after being notified they didn't have permission. And that makes sense. If we're going to make an implied license argument, with any implied license, an explicit license immediately overwrites that implied license. An implied license is only there in the absence of something explicitly told. So once he said, hey, you don't have my permission to do that, they had to remove the content in the story. So those are 2 things about this ruling that are interesting. All in all, I disagree with this ruling, but Israel is kind of well known for having, shall we say, interesting copyright rulings, so I'm not terribly surprised that they would be different than most of the rest of the world in this matter. Obviously, a lot of thoughts float into my head. Will spam blogs start relocating to Israel where it has better copyright protection? I don't know, and I seriously doubt it. Copyright issues for these sites is probably only a minor % of their concerns. But all in all, a strange ruling from Israel that I'm sure many will find disconcerting. I'll have more on this on Plagiarism Today later, but until then, this is Jonathan Bailey, signing off.